Well, good morning, everyone. My name is Andrew Brown, barrister at Radcliffe Chambers. I'm joined by Lauren Kreamer, also barrister at Radcliffe Chambers. Say good morning.
Morning, all.
We're here to discuss insolvency law in this junior program on this grey, well, mildly bright morning now. And we'll be talking about two subjects this morning. We'll be talking about income payment orders, and we'll be talking about extensions of administrations. So grab your popcorn, put on the seatbelts, and get ready for an exciting discussion of insolvency law. I'm going to start out by talking about income payment orders as the warm-up act. Lauren will follow with the much more interesting discussion after that. So with that being said, anything to add, or shall we jump right in, Lauren?
No, go ahead.
Go ahead. Thank you very much. So everyone, I've shared my screen. Hopefully everyone can now see it. And hopefully we're now on full screen as well. So as I said, I'll be speaking about income payment orders. Obviously, these exist within the scheme of bankruptcies. So I'll be focusing on personal insolvency. Lauren will be doing corporate insolvency this morning. So what is an income payment order? Well, an income payment order is essentially an order of the court whereby a trustee in bankruptcy can garnish the wages or income of a bankrupt. Generally speaking, I don't know how many of you have come across these, but I found in practice these are relatively unused applications. For whatever reason, often bankrupts will agree an income payments agreement, which is essentially an agreement to pay a certain portion of their income. The bankrupt might simply have no income. Obviously, if they're bankrupt, their debts exceed their assets, and it might be that they simply lost their job, or general apathy for actually making the application on the part of the trustee. So the problem with income payment orders, as we'll discuss, is they have to be made rather speedily within usually a year before the discharge of the bankrupt. So often, if one doesn't get one's act together, the time for actually making an income payment order application can expire. However, what is interesting about IPOs is they can come from multiple sources, not just your traditional idea of a salary. And from a tactical perspective within a bankruptcy, they can be extremely useful for getting early funding to pursue later legal advice or analysis for larger claims. And we'll discuss that at the very end. So without further ado, let's talk about the background of what an income payment order is. Well, for policy reasons, bankrupt's income has always fallen outside, or in modern insolvency law, has fallen outside the scheme of what is property within the bankrupt's estate. I've cited the decision of Lord Justice James in the Court of Appeal in Re James 18 or Re Wilson 1878, which is one of my favorite insolvency judgments, simply because he notes that an exception was absolutely necessary in order that the bankrupt might not be an outlaw, a mere slave to his trustee. So in essence, as a policy perspective, the income of a bankrupt has always been excluded to make sure that they don't become absolutely destitute on the street and become outlaws, essentially seeking anything they can to survive. However, in the early 1980s, the court committee and the court report decided that there should be a means by which trustees can try to seek wages or income above what is necessary for the bankrupt to survive. That in essence, creditors shouldn't be put out by not being paid, where a bankrupt might have declared himself bankrupt but might be pulling in tons of money under some highly remunerative salary. So IPOs were brought in the Insolvency Act in 1986. Now, what actually does the Insolvency Act say? Well, Section 310 of the Insolvency Act, I've summarized two, or I've put up two of the subsections, what is actually 9 subsections. But in essence, the court may make an order. So the court has a discretion to make an order claiming for the bankrupt's estate so much of the income during the period for which the order is in force as may be specified. That's the basic power, but that is limited. So the court under subsection 2 cannot make an IPO which would reduce the bankrupt's income below what his reasonable needs to survive might be. Additionally, if the bankrupt is residing with family, the family's interests must be taken into account. Now, we'll come back to that in a second on a judgment that I dealt with on appeal earlier this year. It's quite an interesting point all about families in this matter. But ultimately, the thing to take away is that this is discretionary relief which the court might grant to a trustee. So it is incumbent upon the trustee to investigate, and we'll talk about this a little later again, what potential income is out there, what reasonable needs the bankrupt might have, and what benefit might be derived by an IPO. But what actually constitutes the income from which an IPO can attach? What can the trustee take? Well, subsection 7 defines that as any payment or every payment in the nature of income which from time to time made to him, or from time to time he becomes entitled. And that can include, in the rest of that section, discussions about pensions. Now, the obvious starting point is a bankrupt's salary. A lot of people go bankrupt and keep their jobs. That's just a regular element of daily life. Their liabilities outweigh their assets. They can't meet the cash flow test, but they get to keep their job. So the starting point is always to look to see whether the bankrupt has a job and how much they're actually earning out of that in the normal course of investigations. That would be the first place to start. However, it's not the only thing that an IPO can attach to. In the case of Fisher, Receiver, and Baker, the bankrupt was a professional gambler. I really enjoy the background of some bankruptcy cases. This was a professional gambler who, after bankruptcy, had managed to acquire, I think it was about £10,000 by successful gambling. And the question then became, is this income? And in this case, the successful gambling occurred before the making of an IPO. So the question was, can an income payment order actually attach to income which might have preceded the actual application, but came after the actual bankruptcy order itself? Well, Mr. Justice Warren in that case held that, yes, the IPO can attach to not just salary, but something akin to lump sum payments or periodic payments in the source or in the kind of income, or a professional gambler in this case, had been accrued or had accrued between the bankruptcy order and the actual making of the application. So you don't just need to look into the future to see what might come down the road. You should also look to see what has come in the door, essentially, between the bankruptcy order and you actually making the application. But what about pension payments? So obviously pensioners go bankrupt as well as everyone else, and often they have private pensions. Can we attack those private pensions? Well, if a pension is in payment stage and they're receiving a monthly amount from their pension, then yes, a trustee can garnish part of that payment. That can be highly remunerative for an estate if the person who's gone bankrupt was on, say, a defined benefit pension scheme and is drawing a percentage or a payment akin to their final salary. And when they retired, that could be a significant amount of money which is coming in the door. Additionally, pensioners often, if they had children, those children will have moved away, so their reasonable domestic needs might be lower than they otherwise would have been, say, when they were still in employment. It's important to look at these pensions and to actually see whether periodic payments are coming in, because pensions themselves will sit outside of the insolvency scheme and sit outside of insolvency property. So the trustee normally can't just take a pension, but in the IPO, they can take an element of the periodic payments. So look to see, is your bankrupt a pensioner and how much they might be drawing. But what about lump sum payments out of a pension? Well, I can see, having done these notes relatively quickly before this talk, that I have two parentheses with no case law in the middle. Interesting bit of case law has happened in the last few years on this. It was originally thought that a trustee could compel a bankrupt to force them to take a lump sum payment of their pension to which they were entitled, but were not required to take. More recently, the Court of Appeal in Horton and Henry said, well, no, that's not right from a public policy perspective. Under the Welfare Reform and Pensions Act, the trustee does not have the right to compel a bankrupt to take a lump sum payment out of a pension. They can only take an IPO over periodic payments coming out of the pension that the bankrupt has already willingly decided to draw down or is drawing down just by contractual right. However, and that was a policy element, however, there's been a more recent Scottish case, God love the Scots, from the Sheriff's Court in Cook and Accountant in Bankruptcy, which noted that actually the Court of Appeal in Horton and Henry did not preclude the garnishing of a lump sum, which the bankrupt willingly drew down during the course of the bankruptcy, it only prevented the trustee from compelling the bankrupt to do so. So there is scope out there that if a bankrupt does have a large pension pot, decides post-bankruptcy to draw down an enormous amount of it in a lump sum, thinking that they'll be free and clear, there's potential scope for trying to garnish that as well. But how much can the trustee actually take? So we've talked about what you might be able to take money from. How much can they get? Well, the elastic term in Section 310 is reasonable domestic needs. As I said, bankrupt can't be left destitute. We don't want him to turn to outlawry or banditry. We definitely don't want that. So ultimately, this is a fact-sensitive issue in every single case. You need to look, if you're for the trustee, at the individual person, what their domestic needs might be, and what their income is to be set off against that. It's a balancing exercise, ultimately. So if you're acting for the bankrupt, then it's incumbent upon you to establish in evidence what that reasonable need might be. From an evidence standpoint, if a trustee brings an IPO application and the bankrupt puts nothing in, then it's likely an IPO will be made. The question is how much will it be made for? Well, in the case of Bowles and Trefalov, the former chief registrar, Baster, in his own style, held that where there was no evidence as to what the actual reasonable needs of the bankrupt was, he just set the minimum as the London living wage, which is obviously less than a lot of people would claim their reasonable needs might be, especially if they have children or other obligations. Well, what about family members? So under subsection 2, the needs of any family members are taken into account. The court must take them into account as well as the needs of the bankrupt. There's a tricky bit of statutory interpretation here, which I recently dealt with on appeal, and it's the issue of what exactly constitutes family. Section 385 of the Insolvency Act says that family is those persons who live with the bankrupt and are dependent upon him or her. That's it. So it doesn't mean that you have to be a spouse. You don't have to be a blood child. You could be an adopted child. You could be a partner. As long as you are residing in the same house and you are financially dependent upon the bankrupt, then you fall within that ambit. However, that can exclude a number of people, such as separated spouses or ex-spouses, or in the case of a separated spouse, if a child is living with the separated spouse rather than the bankrupt, and the bankrupt, say, has some sort of moral or other obligation to pay child services, then they don't actually fall within the definition of family. So they are not a requisite consideration for the court under subsection 2. I should have said, I skipped this bit on my slide, if a child is residing with the bankrupt and they're going to private school, those private school fees do constitute under case law a reasonable domestic need. So you have to take those into account. So bankrupts who are sending their kids to Eden, it looks like they continue to get to send their kids to Eden for doing, even though they've gone bankrupt. Well, I dealt with a case on appeal recently called Refolds in front of Mr. Justice Marcus Smith, which was all about an issue where, in short, the ex-wife of the bankrupt, who's now living in Italy, and the bankrupt, of course, is living in England, claimed to have been dependent upon a share of the bankrupt's pension proceeds, monthly drawings. We, as the trustees, were claiming that sum as well, saying, well, she's not family and she doesn't need these things. At first instance, up in the ICC, the judge held that there was no evidence and that the ex-wife fell outside the ambit of family, so he would not take her interests into consideration, and he made an IPO for the amount he sought. This was appealed on the issue primarily of whether the ex-wife fell within the boundary of family and whether the court was required to take her interests into consideration. Well, on appeal, what Mr. Justice Marcus Smith found was that no, the statute is very strict as to who is a family member. Ex-wife, in this case, living abroad, is not a family member. There is no requirement for the court to take her interests into consideration. But ultimately, Section 310 is discretionary. So the court may take the interests of either children, ex-wives, spouses, whoever, into consideration when making an IPO, but that is a balancing exercise. The court must ultimately look to see what the effect would be on the creditors of taking these persons' considerations or taking these interests into consideration, and also what the effect would be on these individuals who claim dependency. In this case, however, while that was the legal decision by the judge, there was an evidential decision as well, which is extremely important from a practical standpoint. If you are making an application for an IPO, or even more importantly, if you're trying to resist it, you have to put in cogent and strong evidence as to what reasonable needs might be and why no alternative sources might be found for funding if you're claiming dependency. In this case, the bankrupt and his former wife failed because they put in no evidence of her actual dependency beyond a bare assertion of the bankrupt. So there must be evidence of the person claiming dependency, of their dependency, and what their other needs and resources might be. You must do that. Reasonable domestic needs, last point on this. I've put this on the slide. I'm not going to go into great detail, but Judge Jones in the ICC, formerly Registrar Jones, held that there's various elements you need to take into consideration as to what reasonable domestic needs might be. You look at essentially discretion. It's a discretionary element. You look at a realistic and humane approach. You look at the importance of the item and the domestic need in the context of reasonableness. And you look at the occupation and station of the bankrupt and the interests of the creditors. Look to see what the benefit to creditors might be. If you're seeking 50 quid on a monthly basis from a bankrupt, and there's absolutely no benefit that will go to the creditors of the bankruptcy estate, but that 50 quid might be absolutely essential to the bankrupt to be able to make some important payment regularly, or just to survive slightly above reasonable domestic needs, then it's unlikely the court would make an IPO. Well, when can an IPO actually be made? It has to be made prior to the discharge of the bankrupt. Now, in most cases, that's obviously 1 year after the bankruptcy is. In most cases, the bankrupt will be discharged automatically at that point. So if you're thinking about making an IPO, you've got to get on your horse relatively quickly. Do your investigations of the bankrupt, determine what their salary or their income might be, and start preparing your application. The courts do not like trustees who wait until the final minute to actually make an application. I cited the case of Chadwick and Nash, where a trustee waited until literally, I think it was the last day, to file an application to suspend discharge and to put in an IPO. The court was rather scathing in that approach. However, obviously, if the bankrupt is being uncooperative, not providing you any information, then you can apply for a suspension of discharge and you can hold fire on the IPO until you have more information, or you file an application for an IPO at the same time as the suspension for discharge, and you hope that more evidence comes out along the way. The actual IPO itself can last for 3 years, no more than 3 years, so it's not going to last too long. And if the bankrupt is made bankrupt again, say a year later after discharge, then the debts of the IPO fall within that bankruptcy. So it just becomes another debt in the second bankruptcy, unfortunately. Finally, if you are making an IPO application, you can direct that the source of the income actually pay those funds directly to you as trustee. I've had cases where that's not been sought, and what can sometimes happen is the bankrupt will essentially receive the funds from whoever's paying it and not pay it over to the trustee. And then you get into the delightful situation of what do you do then, having to compel the bankrupt to pay this money over, bring them back to court, all of that kind of stuff. It's best to avoid that and simply seek the third party to pay the funds directly to the trustee. Final slide. Why use an income payment order? I'm sure I've bored you all to death on this Friday morning. You don't want to be here. You want to be doing something else. IPOs don't seem that exciting or sexy, and they aren't going to net the bankruptcy estate millions of pounds, most likely. Well, while the sums are not actually massive in question, they can be reasonably substantial when spread over 3 years. I've cited in my PowerPoint an example of one case where we got an order for roughly £1,200 per month. Now, add that up over 3 years and you get a significant chunk of change. That can go a long ways to placating creditors' needs, or just even paying the remuneration and expenses of the bankruptcy if necessary. There has been case law to the effect that simply seeking an IPO for the purpose of remuneration of the trustee or its expenses is not reason to not make an order. In essence, you're doing a statutory duty. Fees and expenses are a statutory element under the Insolvency Act. So in order to investigate the bankrupt's affairs and to fulfill a statutory duty, those fees are necessary, and they can form the basis for seeking an IPO. But from a tactical perspective, and this is my final point, seeking an IPO in a bankruptcy can be extremely useful if down the line you're thinking about pursuing a preference claim or some other significant claim against the bankrupt. Obviously, often with insolvency, we have to act on CFAs or some sort of deferred payment schedule if we're the legal advisors. But if an IPO is made within the first year, you'll then know that you at least have some stable funding coming into the estate for the next few years. Now, in most cases, you don't have to bring, say, a preference claim for 6 years after the making of the bankruptcy order, and people will wait a few years to investigate matters as much as possible. So letting the IPO build up a war chest of funds within the liquidate or within the trustee's funds might allow that trustee then to seek legal advice initially on a non-CFA basis or otherwise, or pursue investigations of the bankrupt's affairs, which might be difficult if the bankrupt has hidden money overseas or is not being forthcoming with their details. Those funds can be put to good use for building the foundation for a later case, which might net a significant amount of money for the estate, far beyond what the IPO actually might otherwise give you. Yeah, so ultimately, I think that's my talk. I've managed to do it in 20 minutes and beat my previous record, which, well done me. So,
Okay, as Andrew mentioned, I am going to talk on the corporate insolvency side about extending administrations. These are applications that a lot of you have probably come across before, and which have a propensity to be sort of slightly stressful because they're often made sort of quite last minute, and they're really important in terms of the ongoing administration. Insolvency practitioners get very angsty about them if there are issues, because of course there's a risk of very serious consequences if you don't get the period of the term of the administrator's office extended appropriately or correctly. So I just wanted to set out some of the background, just so you've got all of the statutory provisions, and go through some of the common pitfalls and of course how to avoid them. So I'll start with preparing the application, preparing for the hearing, as promised, avoiding pitfalls, and then a bonus, very new temporary practice direction update. This came into force only on about a week ago, so very new and worth noting some useful provisions in relation to extension of administrations and administrations more generally there. So preparing the application, firstly, I suppose the question is why, as something of an initial point, why extend? There are, as with it's the lawyer's answer, there are a range of reasons and it will depend on the circumstances of the individual case. But generally speaking, it's a point about giving the administrators time to make sure they're achieving the aims of the administration. As you'll know, those things tend to include trying to get in assets, carrying out investigations. I've put on there VAT refunds. They're just a very common one that comes up often. Everything else will have been resolved, but the administrators are still waiting for a VAT refund. So they'll need time to make sure that's paid in. It can also involve pursuing litigation. Again, as we'll all be aware, that almost always takes longer than a year, particularly in the kinds of cases that administrators are typically pursuing. It can also mean connectedly achieving or enforcing a settlement, because again, that there might be a settlement that's been negotiated, but the former director, for instance, needs 2 years to pay it, or 3 years, or what have you, and payment schedules are often agreed, but you will need the administration to continue in order to allow for those payments to be received. And then further down the line from the initial kind of stage of getting in assets and so forth, you then need time to distribute, to determine creditor claims, whether in terms of validity or value. And then the point that you'll see that kind of underlines all this is, and I'll come on to the reason for saying this, but a year isn't very long. A year's all you've got to start with. And it's, as we all know, given that we're in October, a year flies by pretty quickly, and it's often the case that it will take you by surprise how long certain things take, particularly when you're involved in litigation. So how do we go about doing this? Well, this starts from, I've put all the references up there. I'm not going to refer to them, but you'll I think have access to the slides after. So hopefully this will just be a helpful crib sheet for the future. But the administration automatically comes to an end on the first anniversary of it coming into force or starting, and it's as specific as being the same time of day. So I'll come on to that. But again, if you filed your notice of appointment at 3 p.m, then it comes to an end at 3 p.m. on the day in question. So it's not the end of that day, for instance. But before, and I emphasize, I haven't put it in bold, but I should have, before the term of the administration comes to an end, it can be extended either by consent, so that's the consent of the company's creditors, or court order. I'll mostly focus on the court order side, but the company's creditors point is helpful, and I suppose the bulk of administrations, or the majority rather of administration extensions, come about by way of consent of creditors. And creditors' consent is limited, however, in that it can only extend the term of the administration for a year. So again, a year's not long. 2 years also can not be a very long time in the grand scheme of things, particularly, as you can imagine, if you've got complex administrations where it essentially takes you a year to get to grips with what's gone on, to get all the information in that you need, and to speak with the people you need to speak with. So you can get a further extension from creditors, but only by a year. And creditors can only consent to the extension once. So you've got your one extra year, which is a sort of acknowledgement by the court that they would be a bit overrun with applications if you had to apply to the court after the expiry of 1 year. But by the time you get to 2, the court tends to think, well, we need a bit of oversight here. We need to understand why it's going on for so long. So I think that's the rationale there. And creditors you can't do it the other way round. So you can't start off getting a court extension and then go for the creditor option. It has to be creditor first, then court later if you need a further extension. Importantly, I have put it in bold there, you can't get the extension once the administration has already expired. That applies to creditors, but as I'll come on to, it also applies to court orders. This is a slightly technical distinction between who you need to get consent from. Where the administrator has made a paragraph 52(1)(b) statement in the proposals, I won't go into the detail of that, but it's just something worth bearing in mind to check on if you need to make this, or if you need to get consent of creditors to extended administration. If the administrator hasn't made that statement, so that means that he didn't say that the company has insufficient assets to result in a distribution being made. That's a lot of double, triple negatives there. So useful to probably go back and check the provision that I'm referring to. But in that circumstance, you need to get the consent of each secured creditor. So each is important, not just one, but all of them. And if the company has unsecured debts, the unsecured creditors. If the administrator did make a paragraph 52(1)(b) statement, then you need the consent of the secured creditor and any preferential creditors. And if the administrator thinks that there are sufficient assets for the distribution to preferential creditors to be made, that's when you need to get their consent. If not, then you don't have to bother. There's nothing that you don't have to do, sort of typically as in insolvency stuff, you don't have a specific form for obtaining consent. There's no particular document, for instance, that needs to be signed, but it has to be obtained separately to the procedure I'm going to outline, which is the deemed consent procedure. So essentially, you can just write to the secured creditor and ask them to confirm, and they will typically provide confirmation. It tends to be in their interests for the administration to be extended, and so that will be that's usually a relatively straightforward process. Then you've got this paragraph 78(2) capital A, consent to an extension requires the administrator to seek a decision from the unsecured or preferential creditors, depending on which process, as per the previous slide you're following. So you can either use a decision procedure or you can use the deemed consent procedure. I haven't gone into the detail of those, but I'm happy to pick up on that after the seminar if people want to talk a bit more about those processes. But those are the ways in which you can obtain or seek a decision from the unsecured or the preferential creditors. An important rule to bear in mind: a notice by which you request consent has to inform the creditors of the reasons. So you can't just make a bare statement that we want an extension. You need to explain why. The rationale there is that creditors should be able to reach an informed decision. It's not just a formality obtaining their consent. It's you are seeking a decision from them, and they should be able to make that decision based on concrete reasons, rather than having to sort of guess or work it out from other documents they've got in relation to the administration. And then we come on to the court order side, which is clearly the administrator can apply to the court. Multiple extensions can be sought and often are. Clearly, the longer it goes on, the better your reasons perhaps will need to be, or at least the same level of detail will need to be provided each time. You can't just say to the court, oh, well, you waived it through, or you agreed it on the last occasion, will you just waive it through this time? That won't do. It needs to be as coherent and as detailed in the ways I'm going to come on to explain every time. But it's worth bearing in mind that multiple extensions can be sought, because you don't need to seek an extremely lengthy extension, and often the court won't be prepared to grant one. So there are examples, for instance, prior to Brexit, of the courts being prepared to extend administrations, but only up to the point that Brexit would start to have an impact, because it couldn't be sure what the effects of Brexit would be. You might imagine that very similarly with COVID might well be a reason for seeking an extension, and indeed has been in a matter I've done recently, where it was the administration of a credit union. And by their nature, credit unions have debtors who are sort of in financial distress often, or certainly not in a strong financial position. And those are exactly the kinds of people who COVID has affected the most, and therefore prospects of securing recoveries tend to be pushed back a little by events like COVID. Not that there are any other events that are comparable, but COVID is clearly a reason that you might need to seek an extension. But again, as far as the length of the extension goes, you can see that it's not, I wouldn't think, going to impress the court to say, well, the effects of COVID could go on for years, so can we have a really long extension because we don't know what's going to happen? Much more likely the court will say, well, you can have a year or you can have 2 years. But let's come back and we'll see where we've got to by that time. This is where I said before should have been highlighted. You have to apply before the administration term has expired. The court will not extend an administration after it's expired unless there are exceptional circumstances. I'll come on to that, but that's worth bearing in mind. Here's where I'll come on to it. Before the administration has expired, if the term does expire, but the application was made and not listed or not heard, but the application was made while the administrator or administrators were still in office, the court does have the discretion to make an order, but only in exceptional circumstances. So in the case that I've put in there, re-TT Industries, the exceptional circumstances were that there had been some series of administration errors on the part of the court. So the application had actually been made in good time, but hadn't been listed, and in spite of their efforts to get it listed, there had been an error and it had essentially been listed on the wrong day. So the court said, even though the term had expired by the time the court got around, or the court listing office got around to listing it, that was okay. It would make the order extending the administration in any event. Bear in mind always the provisions of the PDIP. Para 8.3 is the one you care about most in relation to these kinds of applications, and you will fall foul, that people often fall foul of this, so bear it in mind. They have to be made, it says should be made, but for the reasons I'll come on to, you really should make them at least 1 month before the end of the administration. So that's a kind of helpful guideline to have in mind for when you need to start thinking about making these applications. And if you don't, you can still make the application. You haven't lost your opportunity, but the administrator has to explain why and provide supporting evidence to explain why it's late. If that's just we forgot, then you should be upfront about that. If there's an error, if a fee earner was on holiday or something similar, if the diary didn't sync and the diarized reminder wasn't there, then just say, but you should provide some evidence of the reasons for that. And the effect will be costs. You won't get your costs of making the application provided for typically, unless you've got a friendly DJ or ICC judge who you can persuade you should have your costs anyway. I say DJ or ICC judge. Practice Direction Para 3.1 says that you should make these applications to either an ICC judge or a district judge in a district registry. In London, these are one of the types of application that are transferred to the County Court Central London. I emphasise that for reasons I will come on to, but always bear in mind that while you have to issue in the High Court and it does go to the Rolls building, they will then transfer it. They'll then look at it and transfer it to Central London, and it will be put in a list in Central London, which is of course still hearing everything remotely, or most things remotely, and the High Court still hearing pretty much everything remotely unless the parties agree otherwise. Preparation for this. So all you actually need pursuant to the rules is an application notice which sets out the reasons. I would recommend that you put in a witness statement. It's almost always needed, unless you've got the most straightforward of cases. It's always worth putting in a witness statement for the time it takes. You've already done all the thinking about why you need this extension, and you've had to set out reasons. So a witness statement is typically a good idea, not least because these tend to be time pressured, and you don't really have time for adjournments. You might have time for one if you've made it in good time, but you're not going to have time for multiple adjournments for the court to see further information. So it's a very good idea to get your witness statement in with all of the detail. I've set out there some of the things that I would expect to see in a witness statement, and it's just a bit of a checklist. Reasons obviously is the predominant one there, but also perhaps equally importantly, the detail of any previous extensions. I'll come on to my reasons for setting that out at the end, but it's a very common pitfall, not having details of previous extensions that have been either granted by the court, though those tend to be more straightforward to evidence, but very commonly there's problems with the evidence in relation to creditor obtained extensions. I'll also emphasise estimated outcome statements. That tends to be a thing the court will expect to see, and will want to know that the aims of the administration continue to be achieved by the administration continuing. And an example of that, or a common question is, well, is the administration still achieving more than, for instance, insolvent liquidation would, or what have you? So it's worth having a comparator there which shows the reasons financially that you're saying that the administration is worth carrying on with. And all of this should come with evidence. They're not chunky applications typically. They don't need reams and reams of documents, but the important ones do need to be in there. Perhaps because it's not a very chunky application, it will be all the more obvious if you haven't included evidence of certain things, and in particular, details of previous extensions. The thing judges always say is that they need to be sure that there is still an administration to extend. So if on the face of it, someone was appointed on the 1st of January 2019, and you've put in an application in advance of 2020 saying that you saying that you need an extension, the court needs to know, if you've put an application in January 2021, you've obtained an extension from your creditors, then you need to show the court that you did obtain an extension or consent to an extension from the creditors. So often, as I said earlier, that's as simple as having a letter from the secured creditor, alternatively evidence of the deemed consent process or a decision process. But it would surprise you that how often that's not easily or readily available. Now, to an extent, that's difficult if you're from the solicitor side, because often IPs will have done that themselves. And so it's not always something that you've been in control of, but nevertheless, ask for it early, because it may be that IPs need to dig into their archives or dig back into emails, and are not going to have time to do that on very, very short notice. So always provide evidence that the extension was obtained. Make sure the bundle contains relevant correspondence. It's helpful, for instance, to show the court that the secured creditor also consents, or preferential creditor, or anyone else who matters or is relevant to the particular facts of your case, has consented to a further extension. And you should provide that to the court, or alternatively, if you haven't put it in the bundle, to counsel, so that they can provide it to the court if they're interested in seeing it. And that applies to anything else. It's always better, obviously, to have it in the bundle or to have it formally lodged. Not ideal to just send it to counsel, but often judges, as you know, judges will look at documents if counsel have them, and if the court wants to see them, if it will help. So do always send those over to counsel. Now, these applications are at the discretion of the court, essentially, but there's some helpful guidance from Mr. Justice Snowden in the Re Nortel case, which I've set out there, and it's a paragraph I typically include in skeleton arguments on these kinds of applications, and it refers to some of the sorts of things that I've set out, but it's those three Roman numerals in the middle. One, whether the purpose of the administration remains reasonably likely to be achieved, whether any prejudice would be caused by the extension, and any views expressed by the creditors. And those are just the questions that the court will typically be asking itself, whether specifically by reference to that list or just as a general approach to these kinds of application. But it's helpful guidance, and it's worth bearing in mind when you're drafting the application. Ask yourself these questions such that the court doesn't have to, essentially. So the pitfalls. As I say, because these are time pressured, you do often see these kinds of things, and it becomes quite stressful immediately before the hearing, particularly if the court lists them at short notice, and therefore you're only able to instruct counsel at short notice, and therefore things get sort of discussed and picked up at quite late in the day. Applying less than a month, as I say, you put yourself at risk of not getting costs on the administrator's behalf of making the application. It's not going to be the most expensive application you've ever made, but it's still, you still want the costs, and you're unlikely or less likely to get them if you've applied less than a month before the administration expires without a good reason for that. Or crucially, applying after the administration has expired. You just can't do it. You're not going to get your order unless there's the sorts of circumstances that I've explained, or there's something exceptional, which will very rarely, by definition, arise. The court needs to be satisfied of the things that I've set out, the Nortel guidance, and more generally that this is an appropriate case to extend the administration. Firstly, that includes evidence of any previous extensions, as I've already set out, but also the detail of why the extension is required. It will often seem like you're stating the obvious in the witness statement, but put in the reasons. As I say, if they are that COVID has delayed your prospects of recovery, then put that in. If there's some long-running piece of litigation, and the reason is as simple as the litigation is still ongoing, put it in. Just explain very clearly to the judge why they should extend this administration. And also, you're going to want to say what the administrators have been doing a bit more generally. So it's not going to impress the court terribly if you show up and say, "Oh, we just need more time to work out what assets the company's got," and the judge is going to say, "Well, what's the administrator been doing for the last year or the last 2 years?" And if there's nothing you can point to, as you can imagine, it's not going to be a terribly impressive application. Again, failing properly to follow the deemed consent procedure in relation to creditors' consents, worth making sure that you're following the right processes there. And then avoiding them. Diarizing, it's obvious, but particularly where you've already been instructed in relation to an earlier extension, so an extension obtained by creditor consent, put in your diary the expiry of the term of office, and put in your diary reminders 2 months before, because you've got to make the application a month before. You don't want to realise on the day that you've got to get an application together by 4 p.m. Or by whenever the expiry is in the course of that day. So I would recommend diarising it well enough in advance to get the evidence all together and get the application brought together properly. I flagged up Central London. I didn't want to put anything too pejorative in my actual slides that are going to be circulated. It's going to take so long. Everything takes so long. So assume that this is going to be a painful and lengthy process. You can see exactly why the re-TT kind of issue arose. Court admin error, failing to list in time. I've no doubt that they got the application in plenty of time. It just didn't get listed. And you really have got to have it heard, of course, by the time that the expiry of the administration occurs. So given that you've got this additional procedural step of it having to go before an ICC judge, them transferring it to Central London, it's only across the road, but nevertheless, that's not a quick process. So don't leave that to the last minute. And it's not like if you renew your passport early, you lose the extra time. You're not going to lose any extra time on the administration extension by getting the application in and heard early. The order will still take effect from the current expiry of the term, and will run another year or 2 years or however long you've obtained. So there's no reason not to get it in plenty of time. Again, ask your client first thing, because it's the thing that tends to come up the most often or be the most tricky for reasons I can never quite fathom. But there's always difficulty in retrieving records of consents given by, in particular, secured creditors. So worth checking on that and getting those early. And make sure that the witness statement is thorough. It's for all the reasons I've already set out. It doesn't need to be a day-by-day diary of what you did in the administration today, but make sure it's sufficiently thorough to satisfy the court that this isn't a case of just slow conduct on the part of the administrator, that they have been doing stuff in the preceding year, but that there are good reasons that it needs to be extended further. And then just don't forget as well the notification requirements once you've got the extension. So for extensions by the consent of creditors, you need to notify the court, the registrar of companies, and all the creditors that you've got your extension of a year, or whatever it is. For extension by order of the court, obviously you don't need to notify the court, but you do need to notify the registrar of companies still, and the creditors. And the rules provide that has to be as soon as reasonably practicable. So again, it's an easy thing to forget because you think, I've got my order, great, that's job done. If you realise 6 months later that you forgot to lodge these things, then that is clearly not as soon as reasonably practicable. If it takes you a week or so, then that's unlikely, or a couple of weeks, that's unlikely to be a problem. And the notice, that's just a reminder of the detail that the rules provide as far as the notice, the requirements for the notice. This is important because it's an offence not to provide this notification, so punishable by a fine on summary conviction. So important to make sure you remember to do it. And then finally, you'll be pleased to hear on what is almost the end of this Friday morning, the new temporary practice direction. Now, I had grand plans for explaining to you all the conflicting case law. There are about 6 different High Court authorities on the effect of filing notices of appointment of administrator or notices of intention to appoint an administrator outside of court opening hours. So I had one last week where we had filed the notice of appointment at 8:56 a.m. On a weekday. The court counter opens at 10 a.m. And the question was whether this was a problem, whether it was a defect, whether it needed to be remedied, and if so, how. And then one day after my hearing, this was published. The link will be, I think, in your slides that you'll receive after. And it resolves the questions. It would have been extremely helpful and saved the poor district judge I was before several pages of my skeleton argument if that had been published a couple of days earlier, but never mind. paragraphs 3.3 and 3.4 of that temporary practice direction, which it's worth reading more generally if you haven't spotted it, because it's got some other stuff about winding up petitions and so forth moving forward. But they say that where a notice is CE filed outside of court opening hours, it is to be treated as delivered to the court at 10 a.m. on the day the courts are next open for business. That was what Mr. Justice Zaccaroli had said in a recent decision, but there had been conflicting views about this. So some said it should be deemed to have taken effect when it was filed, and there were various sort of different ways in approaching it. But essentially, the rationale seems to be this: if you had turned up and left your notice on the court counter when somebody arrived and the court counter opened at 10 a.m, they would have picked it up then, and that's when it would have been filed. So the same sort of view is taken of CE filing. You can't file it outside of court hours, but if you do it, for instance, on a Saturday afternoon, then it's treated as filed or delivered at 10 a.m. on the Monday. This isn't forever, but one might think that this will be dealt with by an amendment to either by a practice direction or an amendment to the rules if need be. It came into force on the 1st of October and it will expire on the 31st of March next year, unless amended or revoked. One would imagine that there will be a further practice direction, insolvency practice direction in the meantime. I don't think we're going to be back to normal and everything back in accordance with the usual procedures by March or by the end of March, sadly, but that's how long it's enforced. So for now, that problem has been resolved, and it's nice to have some certainty on that. And that is my presentation. And thanks everyone for coming. Nice to see your names at least. Feel free obviously to email us also if you have any questions that you'd rather ask by email. And as we say, hopefully see you very soon.
Right, I think that's it.
Yep.